our Code of Best Practices in Fair Use for the Visual Arts. This session is focusing on visual arts scholarship. You can find a copy of the code on the CAA website and on the website of the Center for Media and Social Impact. Both of those URLs should be on your screen right now. This webinar and the whole code project was funded by the Andrew W. Mellon Foundation with initial preliminary support from the Samuel H. Kress Foundation. CAA members can access recordings of all of these webinars by logging into your accounts on the CAA website and clicking on the webinar tab. And during today's webinar, if you have questions that you'd like to pose to the presenters, use the chat box on your control panel and they will answer as many as time allows. So now it's my pleasure to introduce the lead principal investigators for the Code of Best Practices and today's presenters, Pat Aufderheide and Peter Yazzie, both professors at American University. Peter, Pat?
Thank you so much. And how exciting, I've just been made the presenter, which means that we can show you our PowerPoint. One point we wanted to make sure that you understand is that this is the second in this series of webinars, and it to some degree depends on your having seen the first one. So if you feel like you're lost or you wanted more background on fair use or how the codes were made, that first webinar is a great place to go to. Scholars, as editors, as writers about art. We're going to give you a real quick refresher on fair use, but really the heart and soul of that discussion is in the first webinar. We're going to talk about what is included in analytic writing in the code, and we're going to talk about the principles and limitations that affect that. We're going to test our knowledge, and then we're going to show you just a few more resources, which Janet started out giving you a great guide to by giving you those two URLs. So the reason why fair use is such an important issue to you is really very simple. That most people in the visual arts use copyright on a daily basis in some way in their work. But 4/5 of academics and almost all editors encounter copyrighted material in their work every day. And when they don't understand how to employ fair use, what happens is that they delay or they delay projects. Projects take more time, they cost more money. And probably the biggest problem is that uncertainty about how to employ the law when you need it means that you avoid or abandon work. And the amount of people who've done that in the fields of academia and publishing are really quite large. More than 60% of academics have decided not to do something they want to do because they're just not sure about whether copyright will permit them to do that, because they have issues about permissions and licensing. 42% of editors have decided not to pursue a project because of such issues. And what that comes down to is self-censorship. Although we discovered many reasons and gatekeepers in this process, people who can say no, the people who most often say no when you decide to avoid or abandon work are the people themselves who want to undertake the work. In other words, uncertainty leads to self-censorship. So that's why it's so important. And now I'd like to turn it over to my colleague Peter Yazzie to talk about what fair use is.
So thank you, Pat. I am going to talk a little bit about the fair use background for this project, but as both Janet and Pat have said, there's much more content of that kind available in the archived webcast of last time. So very briefly, we know that in the United States we have only one constitutional basis on which for on which copyright exists, and that is the notion that having it somehow promotes the making and the dissemination of new culture. And that means, of course, that there are always two themes that are held in balance in copyright law. One is this idea that creative people will we obviously mean both primary and secondary creators, both in our case artists and also those who think and write about artists and art. But we're also aware that those secondary creators, those thinkers and writers, need a certain amount of access to pre-existing copyrighted culture in order to do their things. And so balance is the watchword in copyright law, and in our law we have a particularly important central balancing feature, which is this doctrine of fair use, which basically says that under some circumstances what might otherwise be considered a violation of copyright is in fact a non-infringing activity, one that we value, that is to say, as a society, rather than seeking to condemn. The question, of course, being, when is that? And the law gives us some answers, although not necessarily all the answers we might like. I'll come to those in a moment. First, though, I want to say two things about the condition that exists around fair use in the law. One is, and it seems obvious but may be worth stating once again, that fair use is non-infringing use, and therefore it doesn't require a license. Sometimes we're asked, well, you know, how would I get permission to make fair use? A perfectly sensible question, but in its terms, in fact, a contradiction. The second thing I want to point out, because it is so important to the background of this project, is that as the courts and other sources of authority continually tell us, fair use is a matter of context, that in order to have a certain level of confidence about whether a given use that you are considering making is or isn't fair, you need to think through the issue, taking advantage of everything you know about the situation. And that means that rules of thumb, you know, so many paragraphs or so many words or so many pixels or such and such a total of square inches on the page really aren't useful in thinking about fair use. And unfortunately, at least from our standpoint, there is an awful lot of that stuff online. We're hoping that those who consider making use of the new Code of Best Practices as a tool will also consider putting a lot of that accumulated, and I have to say honestly, misinformation about copyright to one side. So what do we know today about fair use? Well, we know that there are 4 statutory factors that we talked about last time, but we also know that these days the analysis of those 4 factors, the purpose of the use, the nature of the material used, the extent of the use, and the economic effect of the use, really get organized in judicial decision making around I would say 2.5 questions. And the first question is the purpose of the use transformative? Is it a significant repurposing of the material? Is it something other than a substitution for the original? And if the answer is yes, then the second question courts typically ask is whether the amount of material used is appropriate to the transformative purpose. And then to help them to answer those 2 questions, courts look for information about the field in which the use is being made and the kind of assumptions and values that members of that field have about what is important to do in order to fulfill their mission. And it really is this last insight that is the reason behind this best practices project. When communities of practice talk, courts listen, which means that in advance of making a use that might be fair, you should be trying to think the way a court might think, and there the code will give you some help. Now, I only want to say one more thing about the law of fair use as we know it from the courts today. Again, there's a lot of material about that in the last webcast, but in this one, I simply want to stress, given our topic today, that scholarly and other analytic writing is a sweet spot, or represents a sweet spot in the contemporary jurisprudence of fair use, because courts are quick to recognize that scholarly and other analytic writing don't substitute for the original, be it an original piece of text or an original image, that they are designed to pursue another purpose, and that they are therefore transformative in nature. Courts also recognize, incidentally, that sometimes the appropriate amount of material to use in support of an analytic argument may well be the whole text, or the whole image, the whole short poem, or the whole quotation, or as here, the whole image. Now, the code has got three. You want to take over, Pat?
No, but after this slide, I'd like to go to the web so that we can look at the actual section.
Perfect. So this section of the code, the section about analytic writing, and again, all of the information about how this was devised and how the consensus of the field was determined and then vetted, is in the former webcast. Like all the other sections of the code, this one has three important parts. The first is a description, an attempt to lay out the scope of the fair use principle that follows by describing the activities to which it applies. The second is the principle itself, which is a relatively brief, relatively broad statement affirming the applicability of fair use to the category of analytic writing as clarified in the preceding description. And the last part is a series of limitations. These limitations were the subject of most of the debate and discussion in the groups out of which the code arose, and they're of essential importance. They are integral with the principle. One cannot be separated from the other.
And I lied because actually we put the information directly into.
Well, let me continue then and talk a little bit about this slide, and then we'll go perhaps then
and the next one
to a description. And that first, I wanted to say a little bit about the nature of, or the scope of, this principle. And the most important point that I want to make is the second point that appears on this slide, namely that it was the strong and considered view of the representatives of the visual arts community who came together to make this code that analytic writing should be understood as a broad rather than a narrow term. That the category of analytic writing, in addition to reaching academic monographs and journal articles in specialist periodicals, also had a much, much broader reach, including catalogs, art blogs, and many, many other existing or emergent fields. They also were very clear that the principle and its associated limitations were non-platform specific. That is, that they were as applicable to the new emergent electronic media as they are to the well-understood analog ones. And here they are. And the code states them a bit more formally, but in essence, the essential limitations to the general principle that fair use applies to analytic writing are that the connection between the material chosen and the purpose or goal of the analysis should be clear and articulable, that the right amount should be employed, a proposition we already understand, whether that amount is less than or potentially all of the material, and that this notion of proportionality goes not only to size but also to image quality. The groups were very clear that users of pre-existing material in the context of analytic material should think carefully about the status of born digital works, which have some particular vulnerability to being subsequently misappropriated. They felt very strongly that the fidelity of reproduction was an important consideration in determining whether or not a use should be considered fair, and likewise they were of the view that attribution was of critical importance. I want to pause for a moment on the last two of these propositions and point out that these are matters, fidelity and attribution, to which literally the law of fair use, as it is in the law books, does not speak. But because this consensus, the consensus documented as a consensus around best practices in the code, is at least as much an ethical as a legal one, these two propositions were of enormous importance to the informants who came together to make the code and have been recorded faithfully here. Back.
Terrific. Okay, before we go any further, Peter, somebody's asked a question that came up in the last in the first webinar, but I think we can address it real quickly, which is the question of fair use is just a defense, not a right. Could you just address that before we go further?
Oh, I'd be very pleased to. In a hyper-technical legal sense, that proposition has some limited validity. It's wrong because literally the Copyright Act itself recognizes fair use as a right in Section 106F4, but it has a certain weight. Why? Because in a court proceeding, if one were, however unlikely, and it is unlikely, to be formally challenged, one would, as the defendant in an infringement action, raise the issue of fair use by means of a so-called affirmative defense. However, and this is important, the same is true of many of our most important First Amendment-related rights. In a defamation action, one raises the notion that one has a privilege under the public figure doctrine, or for that matter, the notion that the allegedly defamatory conduct or content is in fact true by means of an affirmative defense. So, in fact, of course, like fair use, any important right can be descriptively both a right in the sense that it is ours to exercise under, in this case, the First Amendment, and a defense in the sense that it is asserted in that way in the context of formal legal procedure. That characterization takes nothing away from the strength, the utility of the fair use principle.
Great, thank you so much. So we hope that you have a basic idea. We actually kind of hope you've taken a look at the report, at the code as well. But we'd love to kind of go into the test our knowledge segment. For some reason, my computer's freezing. There we go. And here's our first point. If you take a look at this example, so you are writing an academic article on a 20th century expressionist painting. You have 9 color images, they're about a quarter page each, and what you want them for is to show the evolution of this painter's style. And so you have the quality, you have good enough reproductions. The issue is not do you need access to them. You have access to them. And of course, if you don't have independent access to work, you're not going to employ fair use. But so you have access to them in this hypothetical. But now that you have a journal that says authors have to get permissions for illustrations, as most journals do. So the first question we're going to ask you is, can I employ fair use legally? And we'd like to ask Hillary to launch a poll so we can see what people think. So I see that the no's took a little while longer to vote than the yeses. But let's see, we have 75% voting. If you want to vote, vote now, because we're about to close it. Okay, we got to 80%. That's really nice. And maybe the rest of you just don't want to vote. Up to you. Hit the button now. Okay. Great. Well, thanks, Hillary. So what we have here is around 3/4 of you say yes, and around 1/4 of you say no. So now what we'd like to do is to, no, I don't want to end with the webinar. I'm sorry, I hit the wrong button. And what we'd like to do is to go to the code itself. Take a look at analytic writing, and have you just take a look at the description, which is, we've gone through the fact that it can be in many different platforms, and it can be in many different formats, and 100% can be okay. Note the principle and the limitations, and just spend a minute and send us a question if you think you have a question about whether you legally can do this. Now, we've asked you
I should add that there could be 2 reasons to say no. One could be that in your understanding the principle doesn't apply, or that you don't agree with it, and there is probably nothing that we can say that would or should affect your judgment. But the other reason, of course, could be that you have some question about whether or not the specific circumstances of this proposed use, as we've described them, do or do not comply with the limitations. And so, for instance, we haven't said anything about attribution. We haven't said anything literally about the fidelity of the reproductions. But let's say, just for purposes of the exercise, that these are good representations of the artwork in question, and that they are fully attributed according to the conventions of the field. And that's so because it is a professional, after all, who is doing this essay.
So if we take a look at the principle says, well, scholars, we're a scholar, may invoke fair use to, quote, excerpt, reproduce copyrighted works if, and then let's look at the limitations. The use of the work justified by the analytical objective. Well, that sounds like it's going to be okay because you've chosen these 9 pictures in order to show the evolution of the artwork. The writer's analytic objective should predominate over that of merely representing the work or works used. So in other words, it's not just I want to show these pictures, but these pictures are the ones that show the evolution. Then the amount and kind of the material used and the size and resolution should not exceed that appropriate to the analytic objective. Well, we've said they're around a quarter page. I don't know if that sounds like it's too big or too little to you. But certainly the author in this case believes that a quarter page is going to be enough to show the evolution of this writer's work. Justifications for the use and amount used should be considered especially carefully in connection with digital format reproductions. Okay, I think we're okay because these works were not born digital. Then reproductions of works should represent as accurately as can be achieved under the circumstances. Well, we've said this work is adequate to represent it, so I think that's clear. And then attribute. We didn't talk about attributing, but attributing is a great idea. Okay, let me see if there's more questions. The rights holder may say 9 is more than you need. It seems like there could be potentially conflicts between a number of the a couple of the limitations, wanting to limit the size of a JPEG, but at the same time needing to keep the image large enough. Okay. What if you have access to the images, but that access is governed by a license, for instance, in a large database? And I'm reading these, Peter, assuming that you are going to be the genius who's going to answer these. The wording of the question.
I don't have them anywhere that I can see them.
Okay, I'm looking at them under.
I'm sorry, I couldn't understand.
I'm looking at them under questions. Do we think that it matters for this question whether the artist is still living? And somebody doesn't like the wording of the question.
Well, let me.
Does it matter? Oh, does it matter if the journal is for sale and somebody's having a hard time reading it on the screen? Does it matter if it's the policy of the journal to require permissions? Now, we've separated that into two questions. So first, we're asking, does it matter just legally? And then later on, we'll ask you about the journal. Is fair use applicable if the production is low quality or high quality? And those seem to be the general questions.
Okay. So I don't know why I'm getting so much. Is there a possibility that another mic is open? In any event, the difficulty that I am having is that although I can see questions under question, I can only see about a line and a half of text.
Yeah, that's because you have to click on it. Okay, so let me just ask you.
If I could ask you, please, Pat, what would I click on?
The question.
I see. Okay.
I'm going to skip the questions that are about whether the publisher will let you do this, because that's going to be our next question. Let's just talk about what is legal or not. So somebody says, is this really necessary? Somebody says, is there a difference between using an article, using an artist's work in an article about that artist's work and an article about a particular style or design? And this is a person, Catherine, who is jumping into our second example. So we're going to save that question until the second example.
Okay, I'm working on the questions now. The first question I see is a query with respect to the word necessary. And it's a very, very good inquiry because the code does not speak of necessity. The informants who helped make the code didn't speak of the word necessity. The standard with respect to whether or not the use of an image or other copyrighted material is justified in relationship to purpose is a standard of appropriateness, not a standard of necessity. Necessity would always give you, in effect, the lowest common denominator outcome, and that isn't what anyone in the setting of this project, including the lawyers who reviewed the material after it was developed by the groups, believed was an appropriate one. Now, the second one I have is the question about the living artist, and no. Although I say no with a caveat, in terms of the principle and the limitations as stated, the status of the artist is not a relevant consideration. Fair use applies to all copyrights, and copyrights are as strong or as porous as may be both during and after an artist's life. It is, however, always possible that you as a scholar might choose, as a matter of your own election, to treat the works of living and dead artists differently. Perhaps you have a personal relationship with a living artist, and as a matter of courtesy, you want to seek permission. There's nothing about the code and its principles that makes its use mandatory. It's merely an option that exists, and it exists for both living and dead sources. So let me go down to the next. Does it matter if the journal is for sale? Such an important question. And the answer is no. And again, this is very, very clear from the consensus of the groups, but also very clear from the law as it exists. Namely, the fair use doctrine applies with full force to things that are sold as well as things that are given away or offered on a merely charitable basis. This is a very, very common, widely circulating misunderstanding of fair use, and it's a very important one to address. Let's go down to the next question. Does it matter if it's the policy of the journal to require permissions? Well, the question, in effect, assumes that that's the case. Now, whether you will be able to overcome, on your first effort to do so, the journal's policy, which excludes fair use, is, I think, an interesting question, and one that we'll need to turn to in a moment. Our experience over time with this Code of Best Practices project in general is that creators and scholars have ultimately been successful in helping gatekeepers like journals to change their policies, and that the codes have been valuable in assisting them to do so. We talked about the affirmative defense issue before. We are now, the next question is that you might be worried about rejection of the article. That is certainly true, and if it is essential for you to publish in a certain journal and no amount of effort has been successful in the short term in helping the journal to change its policy, then you're, of course, stuck with that choice. I want to emphasize, though, that insofar as their hoped-for effect on journal editors and other gatekeepers in the field, the goal of this code is not only short-term but long-term. The goal is not only to assist in specific transactions, but to help to influence policies over time. The next question is about sound. I hope that's been fixed. The next question likewise. And then comes, now this is extremely interesting. Someone says, I say that if all the images come from the same source, permissions would be necessary. Well, the question stipulates that all of the images represent the work of the same artist. So in that sense, if I understand the question, that term is present. But interestingly, the unit of analysis in copyright law for the question of whether or not an appropriate amount of material has been employed is not the body of work of a single copyright owner. The unit of analysis is, in fact, the single work. So in both technical copyright law and in the view of those who are behind this code, it is not relevant to the answer as far as a legal matter is concerned, whether we are talking about one artist or potentially 9 artists. And that, I think, brings me to the end of the list. Maybe there are more. Let me look. Oh, I'm sorry.
But you know, even if there are, we might have to proceed in order to make sure that we don't exceed our time frame.
Okay.
What I'd like to do now then is to take another poll. Hillary, could you
Could I just take up one additional question, which is so interesting and important? someone writes, if I get permission for some illustrations in order to maintain a specific relationship, can I claim fair use for other illustrations? And the answer is yes, absolutely. And we have that on the authority of no less than the United States Supreme Court.
Wonderful. So you're now armed with new information. Let's do another poll. Hillary, could you watch the same question again? Thank you. Okay, 60% of you have voted, and let's just hit that button as quick as you can because we want to at least get it up to 80. That's as many percent as people as voted last time. Is it legal? That's the question. And leave aside the question of whether the journal will take it. We're slowing down. Maybe we're only going to get to 75. Okay, going once, going twice, and 94% of you now say that this is legal, and it is indeed. This matches nicely to the limitations of the code in terms of whether you could do this under fair use. So then your other question, which was a very good one, was what do you do with the journal, which has a long history of requiring permissions? Well, that's when the code comes into great utility for you, because when you say to the publisher, I believe I have fair use rights on these pictures, you're no longer having to say that alone. You're no longer having to be the self-appointed lawyer. What you can now say is that the best practices of the field suggest that this is possible, and I have a document that might help you be able to allow me to exercise this right and reassure you in terms of the risk that you would be undertaking if you did that. Peter, did you have anything to add to that? And you might be on mute, Peter. We're not hearing you.
Only one thing, Pat, and that is that we know that over time, the strategy that Pat describes works. The other thing that over time it will be possible to do is to point to journals, other journals, perhaps as well known or as important in the field, that have changed their policies with respect to this question. So, you know, the problems for those who are first adopters are always more severe than those for whom a path has been blazed. But one of the things that we will be doing on the CAA website and on the center's website as well is keeping up-to-date information flowing about how the policies of journals, publishers, and others are changing in result to the code.
And we would be very interested in hearing from you if you do have a conversation with the publisher and learning how it went. We do understand that the College Art Association itself is going to be supporting people who make a request to responsibly employ fair use under the terms of the code. So are we ready? Peter, do you want to say anything?
One more thing. Well, I'd like to say one more thing, which is that one thing I think you can always expect a publisher to want from you in a conversation like this, and that is some kind of an explanation, some kind of a rationale as to why you are doing this, what your purpose is, and why, in your view, because at the end of the day, it's your view that matters most, why the material you're using is kind and quality is the right material. So you're not going to be able ever, nor in my view should you ever be able, should you ever want to avoid that conversation. But I think our hope is that by having that conversation, you will be able, with the support of the code, to convey your arguments more effectively.
Wonderful. So let's just take one more example, and we're going to have to kind of whiz through this one. So in this case, it's a situation like one of the questioners posed, which is the first case you were talking about this expressionist artist. But in this case, it's a book about visionary art. And you're not going to be talking about any of the artists in particular. But you are and focusing on them alone. But you are going to be mentioning these people as part of a trend, and you're going to discuss the styles, trends, and themes here. And you are going to be selecting a variety of artists' work in order to exemplify some of these themes. So the question is, can I legally employ fair use to reproduce the work I've chosen? And once again, what you'd like to do, if you don't have it up yourself, is to take a look at the limitations that are on the screen in terms of thinking about how you would justify using the visionary art that you do choose for discussing those trends. So let's just take a poll. Again, Hillary, we depend on you to launch that poll. Thank you so much. And once again, hitting the button. I think some of you are just getting tired of taking polls. We're almost to 70. Okay, is 70 going to be it? No, we can get a little higher. Yes, we can. Okay, that might be it. Thank you, Hillary. So what we've got is a situation. Begging your pardon, Peter?
Oh, I said ballot fatigue.
Yes. Okay, so we have about 2/3 of you saying yes and about 1/3 saying no. And we're going to just take a look at questions. And let's walk through
one thing even before we jump into the specific questions, because I've got a suspicion about why the breakdown may be different in this case from in the prior case, and I want to articulate it in case by doing so I might anticipate also some of the particular questions. One of the pieces of circulating misinformation in the field of fair use is the notion that fair use applies somehow uniquely to situations in which critique, in the narrow way in which academics might understand that term, is being conducted. And what the principle stands for and what all of the case law around fair use verifies is the notion that although critique is a good example of transformative use, it's not the only example of transformative use, and that pertinent illustration can be equally transformative in its nature. And we intentionally set this question up to be a question involving illustrative rather than specifically critical use, and we did that precisely to raise the issue that I am now articulating and that may have caused some of you pause in answering the question. So with that in mind, let's go to the specifics.
So Peter, here's a question for you. What if there's a copyright in the reproductions that you want to use? And of course, fair use only applies to copyrighted works. But for instance, this person asks, supposing you've scanned them from a recently published book.
Yes. Well, that's a very good answer, and the answer is that the copyright in a book doesn't extend to any parts of that book that are not protected by copyright. And the law, this is not now fair use law, it's the law of copyrightability, is to the effect that reproductions of two-dimensional works are not copyrightable. Now, suppose that this were a picture of a sculpture where the book illustration might conceivably, because of its three-dimensional nature, enjoy some copyright protection. well, then the fair use analysis is potentially applicable to both the photographic copyright and whatever copyright exists, if any, new sculpture or old sculpture will make a difference, the underlying work. So broadly speaking, with that gloss, the answer is yes. It cuts across both categories of copyrights.
So what if the artists are represented by an artist right group and require payment for the use of their images?
Well, again, that's very similar to the question that we had before about journal policies. In other words, it is natural and I suppose appropriate from the standpoint of their business model that artist rights groups would assume and assert that they should license all uses, just as journals, for various reasons, may have, or publishers, for various reasons, may have as their starting point the notion that all uses should be licensed. But the mere assertion of a policy, be it by a journal or publisher or by a representative of a rights holder, cannot overcome the fair use, and I will use the word because there is no other appropriate word to use, the fair use rights of the user. Now, the artist rights representatives may tell you that they take fair use into account and that if the use you're proposing to them is a fair one, they will allow you to make it without payment. But so far as we can tell, they have a rather different conception of fair use from the conception of the visual arts community as documented in the code.
So does everything you're saying about journals apply to scholarly books?
With full force, as well as we said earlier, less formal kinds of analytic writing, such as blogs, and more forms of writing that are located in the museum community, such as analytic catalogs as well.
So one person asks, and I think this person is asking about specifically the artists, do we need their permission or is attribution enough?
Again, if fair use applies, then in the most formal sense, by definition, permission isn't required, even though, as I said earlier, as a matter of courtesy, you might sometimes want to seek it. What the community tells us is that in order for a use to have the best possible fair use credentials, attribution should be supplied.
So what if the artwork originates in a country outside the U.S. with stricter copyright laws?
This should make no difference. The country of origin is not the source of the law that governs on these questions. It's an important issue because not all countries of the world have fair use, although many of them have other copyright exceptions which may in certain circumstances be its functional equivalent. But if a use is a U.S.-based use, then it is U.S. law that applies.
So how about publishing something here, but then also distributing it outside the U.S.?
That's a harder question. That's a harder question because it will depend on the nature and extent of the foreign distribution. So, for instance, if you were in a co-venture with a foreign publisher to produce a book that was designed for general circulation in the United States and France, then I think it would be wise, of course, to consider French law. But if the concern is rather that a few copies of this book may find their way through direct orders or other means into foreign jurisdictions, that should be a matter of no particular concern. Nor should it be of any concern, since we have emphasized that analytic writing can occur in different contexts and on different platforms, nor should it be concerned that the blogs of a U.S. art blogger, which are going out to the world through a U.S. located server, may in fact be received, viewed, and and appreciated elsewhere in the world. Again, that's a U.S. use with U.S. law applying.
Great. So one more time with the voting. You're publishing a book about visionary art. You're selecting a variety of artists' work as illustrations of styles, trends, and themes. You're not discussing at length the work of these artists in particular. Can you legally employ fair use to make your decisions? And Hillary, could you give us that poll for the last time? And people are more confident this time in their choices. They're voting much quicker. And we got up to 70%. Last opportunity to hit the button. Okay, great. Thank you, Hillary. Got it up to 73. More people voted this time. They voted quicker, and 91% say this is fair use. And of course, you want to align closely with the limitations, but this scenario was designed specifically in order to get you to the yes.
Before we wind up, I want to say that these have been really excellent questions, and I am sorry that we didn't have time to deal with all of them at length. However, I do want everyone to be aware that there is an extensive FAQ document relating to the Code of Best Practices, which can be found on both of the websites that you have been referred to, and that is constantly updated. And we will, of course, try our best to update it continually and to take account of some of the questions that were raised today but weren't directly addressed. It's a very good resource. We worked on it hard.
So, for instance, fair use is a mere defense, not a right, a question that came up today. If you forgot the answer or you want to be able to refer somebody to a more authoritative answer than you feel comfortable giving, I just clicked on it. You can see to this section that that you're referring to. But there are also dozens more questions. And if you do not see your question here, we would like to know, because we would be delighted to add a question. So finally, in our last few minutes, we wanted to pick up a few questions that we see people often asking. And I know that Peter, we've addressed the second one, but Peter, perhaps you could just take away the first one.
I can, because this is a very interesting question. It comes up a lot. And it is the question of so-called orphan works, works that you assume because of their date or their assumed provenance are protected by copyright, but where, for whatever reason, it's not easy to tell, indeed not possible to tell exactly who's got or who is administering the rights. Are these a special case? And the answer is no, that the general principles and limitations of the code apply with equal force to orphan works and to works that have easily identified owners who, if you chose, would be only too happy to license your use. At the margin, wherever push come to shove, the arguments for fair use with respect to orphan works might be a bit stronger, but that's a marginal consideration only. So our suggestion would be that the best way to deal with orphan works is to treat them as being being essentially identical for analytic purposes to ones with identified owners.
So I want to whiz through the last two questions way too quickly, but I want to again follow up Peter's good suggestion to take a look at the FAQ on these. What happens if somebody objects to your fair use decision? Estate, ARS, VAGA, anybody. That's where you would really go back to the reasons that you might have given an editor, a book editor, or a journal editor, or you might have made to yourself about what were your fair use decisions, and where you would find referring to the code again to be very helpful, because that can give you the confidence that you have made the right decision. Some estates will object as a knee-jerk effort. They see it, they'll say, where did you license it? They may be unfamiliar with people employing their fair use rights. What typically happens when somebody objects and a fair use right is correctly employed is that there is never a response again from the complainer. As one quick example, in the world of documentary film, where they created a code, Kirby Dick made a film called This Film Is Not Yet Rated, using 134 uncleared clips of major motion pictures, and firmly and dearly hoped that he would get cease and desist letters from the 6 studios that were involved. Because he knew that he had fair use rights, he knew that he employed them correctly, he was not worried at all about what he would tell them, but he wanted to put them all on his DVD as extras. And
there's another thing too about estates in particular, and that is that although they do sometimes reflexively object, and perhaps even arguably should, as a matter of their own sort of housekeeping, we've discovered, not with respect to this code, which is brand new, but with respect to some of the earlier codes, that often copyright owners of this kind, once they receive an explanation, are entirely satisfied with that explanation and not in any way even disposed to go further.
Exactly. So that actually takes us to our last question. I just wanted to point out that Dick never actually received any cease and desist letters. No one of the 6 studios and 134 major motion pictures that he did clips from, nobody ever complained. So the final question, whatever happened to respecting artists? One thing that we've discovered in all of our work, which I think is very important to really think about, is that people care tremendously about being recognized, and that's why attribution, even though it's not part of fair use law, is a really, really important thing. And artists may be grateful for the recognition, they may be not grateful for the way you've discussed it, but in any case you do have the right to discuss their work independently of their approval. But that doesn't mean you should disrespect them, and the most important way that you can show respect to somebody is by demonstrating that you understand that it is their work. This...
And if I might add, I would simply say that for those of you who are going to stick with us, and as I hope you will, attend the webinars coming up, in one of those upcoming webinars, you'll learn also about how much working artists themselves rely on fair use.
Exactly. So to conclude, and we are just about out of time, we want to make the point that fair use gets bigger and larger as a right to the extent that people practice it. So in many areas of work, practice makes perfect, but in this case, practice makes the practice of the field. So to the extent that your journal, your publishing house, your work employs fair use, that actually makes it much, much easier for the next person to employ fair use, and it becomes something that is less scary, more routine, and part of daily life. And it therefore directly alleviates that self-censorship question that we talked about at the beginning. We're reinforcing...
So let us know your success stories, please.
Yes. And this is reinforcing the links that Janet Lande, the program manager for this project, gave you at the very beginning. If you really want to take a deep dive, you can always read our book. And we would be delighted if you would share this webinar, this presentation, and as you have stories to tell about the people you've contacted, ways you've employed fair use, and success stories, please do let us know. Janet is our contact, jlande@collegeart.org. And thank you so much.
Again, thank you very much.